discuss our plan to strengthen protection of domestic intellectual property rights in the area of patents. Our specific goal in this debate is to propose that the United States federal government implement a two-part strategy to support small and medium businesses by establishing government control over this. Our specific goal in this debate is to propose that the United States federal government implement a two-part strategy to support small and medium businesses by establishing the patent rights education and legal advocacy program, which will be further referred to as PRELAP. The goal of our plan are to provide the quality education for SMBs to protect them from the complex and discouraging patent filing process, and to provide SMBs with a legal fund to protect them from patent trolls. The affirmative would like to demonstrate our plan in a clear and concise manner. Consequently, we will have to define a few vital terms. So small and medium business, or SMBs as they will be referred to, are businesses that fail and fall into specific categories concerning income and employee sizes set by the United States Small Business Administration. Patent trolls, as defined by the Federal Trade Commission, are entities that obtain the rights to one or more patents to profit by means of licensing or litigation, challenging an innovative business in court rather than producing their own goods or services. Merriam-Webster Dictionary defines significant as of a notably or measurably large amount. The USPTO defines non-final rejection as an action by the patent examiner which does not close prosecution of the application, which may include requirements, objections, and/or rejections. Undoubtedly, filing a patent is financially burdensome, which with costs of the USPTO averaging about $8,000 to $10,000 to file a singular patent. These expenses include application fees, legal fees, and other associated costs, that is, excluding any fees to fight them in court. It is no surprise that according to the United States Small Business Advocacy Office, SMBs have been filing increasingly fewer patents since 2010, and in 2022, SMBs only made 43% of patent applications. Not only are the fees themselves incredibly expensive, but non-final rejection by the patent review officer can add months or even years to the process, which in turn limits the SMB's ability to profit from their innovation and leaves them more susceptible to the practices of patent trolls. Keep in mind, when you hear that, according to IP Toolworks, about 80% of all patents filed receive at least one non-final rejection, though it is common to receive more than 3 non-final rejections as well. For example, a study by the IP Awareness Foundation found that nearly 60% of SMBs attempting to file patents without legal assistance made critical errors, leading to an average delay of 9 to 12 months in the legal process. In addition to the drawbacks of filing patents, SMBs are frequently targeted by patent trolls whilst going through the filing process or even after a patent is filed. According to the ProMarket.org, they make 64% of all patent litigation cases, and according to Harvard Business Review, the number of firms sued by patent trolls grew 9-fold over the last decade. Now a majority of patents are filed by trolls. Without a doubt, the costs of filing and maintaining patents, the extremely high non-final rejection rate, and challenges and hamperings by patent trolls all stifle innovation and economic growth. It is clear that the United States patent system must be reformed to better support SMBs, encourage innovation, and lastly, protect SMBs from the major issues presented by the patent system. So, to address these issues, the affirmative proposes a strategy aimed at strengthening protection for domestic patents. Moving forward, the first component of our plan is designed to educate any and all businesses on how to create a patent, specifically how to design one that doesn't infringe on the main reasons most patents are rejected. Those reasons, according to the U.S. Small Business Advocacy Office, are a violation of U.S. Codes 102, 103, and the American Invest Acts. As a result of better education, SMBs in particular will become more informed about the patent process, leading them to file patents that wouldn't receive a non-final rejection. Education and mentorship will also empower SMBs to navigate potential challenges confidently, fostering a proactive approach to patent defense. Moving forward, the second part of our plan is aimed at combating the problems of patent trolls. To protect SMBs from their predatory practices, we propose the creation of a dedicated legal support fund. The fund will provide financial assistance to SMBs that are facing litigation from patent trolls. Eligible SMBs will be able to apply for grants up to $150K. To ensure that the legal support fund is used appropriately, eligibility for assistance will be limited to SMBs involved in litigation with entities classified as patent trolls by a pre-established federal database. Now, this database has been kept ongoing record of patent trolls since 2010. The USPTO will manage the fund and work in collaboration with the FTC to maintain an up-to-date list of known patent trolls. The government will allocate $625 million for this program each year. The education aspect of pre-lab will cost about $150 million annually and will include lectures, open forums, webinars, and other forms of education. $25 million will amount to the cost of managing, advertising, and administering the program, and the remaining cost of legal formal costs, $450 million annually. This leads to our total cost of pre-lab amounting to $625 million. This plan will take $200 million from the USPTO budget surplus. Each year, the USPTO means a surplus of about $1 billion, and each year they add about $225 million to the said surplus. Moreover, according to the Congressional Budget Office, the federal government spent $40 billion on discretionary funding involving space exploration in 2023. The affirmative proposes taking $425 million from this federal appropriations to fund our plan. Moving forward to address solvency, pre-lab's approach established goals are such. The education aspect of our plan hopes to decrease the amount of non-final rejections given to patents by 30% within 4 years of implementation. In addition, we hope to decrease the number of cases related to patent trolls by 15% within the first 4 years of implementation. Every 4 years, the USPTO will review the program to ensure that it is meeting these goals. We hope to see non-final rejection rates in patent troll cases decrease each year. The USPTO evaluates our plan and its effectiveness. Moving into our timeline. So, pre-lab will begin implementation in the next fiscal year and will have 3 phases. Phase 1 will last 1 year and will develop program guidelines and administrative overheads at the USPTO, as well as train new staff. We will begin advertisement as well as pre-lab, and finally, we'll begin accepting applications for legal funds. Phase 2 will last 4 years and will include yearly evaluation by the USPTO and adjustment of the program based on feedback, effectiveness, and meeting our outcome goals. Our last phase, phase 3, which will last indefinitely after phase 2, will include continuous evaluation, monitoring, and adjustment of the plan based on new feedback, data, and the IP climate. Just to hit home the benefits of our plan, I'd like to just explain on this and provide more information on this. So by providing education and legal support, we will strengthen the protection of intellectual property rights for all businesses, especially SMBs, ensuring that they are not only better equipped to safeguard their innovations, but will also encourage more patent filings. Additionally, another important aspect of our plan is that it promotes fair competition. Patent trolls often exploit the legal system to target SMBs, which stifles innovation and can lead to monopolies by certain companies. By providing legal support and reducing the profitability of frivolous litigation, our plan will deter patent trolls and level the playing field for SMBs. This will ensure that businesses of all sizes can compete based on the quality of their innovations rather than ability to absorb legal costs. Thank you, and please side with the affirmative.
Good afternoon. Okay, all right. Okay, to begin with, what % of U.S. businesses do you define as SMB?
Well, 99.9% of all U.S. businesses are SMBs. So. Okay.
So is your plan going to be available and applicable to 99.9% of businesses in the United States?
Well, it's for the ones that need, yes, for the ones that will be accepted into this plan.
Okay, and in order to be accepted into the plan, what kind of qualifications are you using?
So it's with SMBs if they're in a litigation process with something, with a patent troll that's defined by the FTC, the Federal Trade Commission. If they're in patent litigation, they will be able to apply for legal.
Understood, but how do you identify which cases in terms of patents are trolls versus not trolls?
Would you like me to read the definition again?
No, I don't need the definition. I'm asking you, how do you determine what is a legitimate patent claim and what is a patent troll?
Well, it's the team deemed by the FTC, and they've already set that definition. We've said.
Okay, so how is the FTC determining this?
I'll read the definition.
That's okay. Okay, we'll just move on. Where are you deriving your funding from?
Okay, so the United States Patent and Trade Office, they have keep their reserve. In 2020, it was $225 million,
okay.
And also we'll be taking it from discretionary funding in the field of space technology.
Okay. And how much is the discretionary funding?
For what? The discretionary fund for all the space technology?
The one that you just mentioned.
It's $40 billion.
Okay, all right. And how much in legal fees are you going to be providing for the qualifying SMBs?
So as we said before, the legal part of our plan is $150 million.
I don't need the budget. I'm asking
are you asking for the grant?
How much in legal fees are you going to allocate?
It's up to $150K.
Okay, and how are you going to determine which SMP deserves or how much money they're going to get?
Again, that will be determined by in case of litigation, how long the litigation will be going, how long the litigation has
Okay,
lasted.
so, understood, thank you. How many staff do you estimate you will need to oversee this program?
So it'll be around 100 to 120 new members in that range.
Okay. And does this include just the education aspect or the entire plan overall?
Education for, oh, okay, education for the, not the education.
Educational aspect you mentioned?
Yes, it is, because I don't only need the education part won't need this. Moreover, we'll also be using freelance workers as the speakers and stuff like that for educational workshops.
Okay, I'm just asking you how many staff overall do you need to bring in order to?
It's 100 to 120.
Okay, understood. And how will the training be done? Who is going to be administering the training?
It's the USPT.
The USPTO, okay. And what fiscal year did you use to determine your budgetary requirements?
Are you talking for which part of the, okay? Because we take it from two parts. Is it the discretionary funding?
You can give me either.
Okay, so discretionary fund was in 2023.
Okay.
And we based the number off the patent surplus, the USPTO surplus in 2020.
Understood. By discretionary fund, are you referring to the OR of the USPTO? The operating reserve?
No. The operating reserve is different from the discretionary fund.
Okay, all right, thank you so much.
Of course.
Okay.
Ready?
Yep.
Cool.
Opponents, judges, teammate, and eager spectators. My name is Raymond, and I'm repping the Rebels negative team. So today, the affirmative or the negative team would like to discuss a couple problems that we noticed with the affirmative's argument. Specifically, the main issue we focused on is the budget. Now, the appropriate clause acts specifically, cited from the National Constitution Center, Section 9, Article 1, applies here, especially to where they're taking their money from. Now, what this act specifically says is that any money allocated to a government agency, which in this case is the USPTO, cannot be allocated to funds and programs as stated by the affirmative. And this specifically targets the discretion fund that they have discussed that they are going to be taking money from. Now, taking money from the USPTO's discretion fund is illegal according to this act. They physically are not allowed to take money out of where they're getting their money from without it being illegal. Thus, their current budget system is inherently flawed. Now, I would also like to touch upon the staff hiring as well. They stated they're going to be hiring approximately 100 to 120 new staff, but according to multiple reports from the USPTO, only about 80 hires maximum per year are currently, that's the current status quo for hiring new people. So hiring 80 new people on top of the amount of people they're trying to hire in the course of 1 year, I believe is what they stated, is going to be very difficult without allocating significantly more resources towards this, which is only going to drain the funding even more. Additionally, they stated that their money is going to be coming from a surplus from the USPTO, but this seemingly is not possible because the USPTO has been in a deficit for multiple years as of now. In the last 3 years, I believe, the USPTO has been going over budget and cannot give out any surpluses. So I'm not necessarily sure where they're taking their money from in this regard. Now, additionally, they stated that all SMBs are going to be eligible for this program, and when questioned on the amount of money they're going to be receiving in certain legal battles, they have just said that it's going to depend on the legal battles. And they've also stated that these battles go up to $1 million. Legal battles actually run on the higher end of that. Usually $1 million is about the cheapest and only for very small battles. Normally they run between $2 and $3 million per battle. And providing aid to all of these businesses that would get into these lawsuits, they've not specified if there's any requirements for these businesses other than meeting the standards they said they have. It's going to cost an extremely large amount of money to fight these cases. And they said up to $150,000. $150,000 out of $2 million to $3 million, most people are going to be getting that maximum amount of money, $150,000. Now, funding all of these SMBs for $150,000 is going to be incredibly, incredibly expensive. And there's no feasible way their budget is going to be able to account for all of these lawsuits, especially across the entire country. Now, additionally, with their plan on educating other businesses, there already actually exists a program very similar to the one that they're creating, and it is called the Patent Pro Bono Program, where free patent legal assistance is provided to small business owners and not medium business owners, but for small business owners, you are eligible for free legal assistance, free, in preparing and filing for a patent application, and is a nationwide network of independently operated regional programs that match volunteer patent attorneys and agents with under-resourced inventors and small businesses to provide free legal assistance in securing their patent protection. Now, they stated that they're going to be providing education to these SMBs for obtaining their own, in securing their patent rights. And this program is currently already in place and already does exactly what they're trying to say. And essentially, they're creating an entirely new organization for seemingly no reason. Now, additionally, this Pro Bono Act specifically states that they're going to be matching volunteer patent attorneys and agents with these small businesses. This advice is already there. They're seemingly giving them even more help than they are already able to provide. There's no necessity to create an entirely different plan just to do the same thing that this program already does. Now, I wanted to touch on their unreliable budget as well. They stated that this plan will be going on indefinitely and it will be monitored for this period of time. Therefore, it's going to require at least a decent amount of money to keep going. And they stated that they're going to be taking the money from the extra money from the USPTO. Now, even if there were extra money, which there isn't, that is an unreliable source of income because say, for example, they're saying that the USPTO does have money. Well, 1 year if it doesn't, this program no longer has funding. Simple. There's unreliable money source here. Additionally, I do want to touch on the requirements for acceptance in a patent troll litigation. Certain small businesses may require more aid. Some may not. That's just how it is. They have not stated whether they're going to be covering a percentage of the total litigation cost up to 150. This specification just has simply not been discussed in this debate, and therefore it is currently impossible to know how much money these businesses are actually going to be getting and whether this money will actually prove to be useful to them. Now, they also stated that the other part of their plan is to combat patent trolls. So combating patent trolls, specifically what they stated is in legal battles. Now, by strengthening the argument against patent trolls, it could potentially result in a significant decrease in innovation through the country as people are scared to get into these patent litigations if they are flagged as patent trolls. Now, they've also not stated whether or not the system that used to flag patent trolls is reliable in this scenario. Of course, mistakes could be made. If these certain companies are flagged by mistake, for example, they could be brought into large legal battles. This is a huge problem, especially for small businesses that may be classified as patent trolls. Thus, it could de-incentivize innovation. Innovation right now is currently pretty prevalent in the United States with the new AI developing all throughout the country. AI is a pretty big contributor to the GDP, the projected GDP of nations all throughout the world. For example, in China, the projected GDP growth from current 2024 to 2030 is 26% solely based on technologies in AI. China is going to be significantly increasing its GDP because of AI and technological developments. Thus, it's only reasonable to assume that the United States will definitely benefit significantly from innovation. Thus, if this plan were to stifle innovation, it would be pretty bad on a global economic scale and de-incentivize innovation all throughout the country. I'd like to close by summarizing a couple points. The affirmative plan is completely redundant, and it is already covered by multiple plans already put in place. And essentially, there's no need to create an entirely new organization to combat these issues. Thank you. I'll decide with the negative.
So are you aware that you mentioned the large taxes will have on the budget? But are you aware of only 0.06 SMEs file for patents?
0.06 is still going to be a pretty large number.
Okay, thank you. Moreover, are you aware that the KDI law firm reported that 49% of patent violations get rejected because they don't have enough information? Wouldn't that suggest that the status quo is not working against for these?
I 100% disagree. If patents are rejected because of missing information that's crucial, it would create even larger
Thank you. Then why is the part that you talked about in the status quo, these pre-established volunteer lawyers that are guaranteed, why is that working if that statistic exists?
It's possible these businesses just simply don't know about that, but that's it.
Okay, thank you. Also, moreover, you talked about the I forget the specific act, but how federal agencies can't take from other agencies. Is that correct?
Yes.
Okay. Well, are you aware that this discretionary funding isn't set for a specific agency; it's set for the specific field?
So specifically, what I stated was, I can find the source in 1 second, but essentially.
Okay, thank you. Moreover, are you aware that the United States Patent and Trade Office, this budget is coming from the fees that they don't use, the specific surplus that was mentioned?
As I stated, there's been no surplus, and there's actually been a deficit multiple years.
Thank you. Moreover, so with the act, because that budget is within the United States Patent and Trade Office, aren't they pulling it? They're pulling internally. Are you aware of that?
Yes, but it's actually illegal.
Okay, thank you. Moreover, are you also aware that 80% of patents get non-final applications, non-final rejections?
Sure.
Okay, thank you. You also said that AI is big. How is this plan not helping AI, especially given the increased patent education to the startups?
I don't see your line of reasoning.
Well, you said that this would harm AI development and harm.
I said it could potentially harm innovation. Innovation, specifically right now, is AI. AI was a talking point in this example.
Okay, thank you. Well, could you be specific on how this would harm that?
Yeah, as I stated in my constructive, harming innovation as a whole is pretty detrimental.
Yes, thank you.
And
how is our plan harming that?
Your plan is could potentially stifle innovation because of other companies not wanting to put their patents out because of legal battles.
Okay, thank you. But are you aware that this gives support to the specific SMB, and moreover, this system that you said was flagged is regulated by the FTC and has a set definition that was set in our construction.
You haven't stated necessarily specifics on how they're classified and whether there's.
Well, are you aware that we gave the specific definition in construction?
I am not. Then sure.
Okay, all right. Thank you. No further questions. Thank you.
Good afternoon, Honorable Judge, worthy opponents, and esteemed colleagues. Today, I stand strong in the affirmation of the resolution, which states that the United States federal government should significantly strengthen its protection of domestic intellectual property in the area of patents, trademarks, and/or copyright. Our plan focuses on addressing this critical gap in how the current U.S. patent system affects SMBs. SMBs represent 99.9% of all U.S. businesses, but according to the USPTO, they only represent 43% of all patents filed. That is a huge disparity. Despite their importance, they are often overlooked in discussions about patent law, and their struggles in this area have serious implications for the U.S. innovation and economic competitiveness, as the negative has demonstrated in the trade war with China and the increased need for innovation. Pre-Lab is designed to bridge this gap and implore SMBs to take a stronger stance in the world of patents. The negative has brought up that there are already acts in place that are helping SMBs with education, but according to the facts that we have brought up in our constructive and in our cross-examinations, it shows that even if that plan is in place, it's not working well enough. They're not receiving this vital education they need to file good patents. As we stated before, according to Big Patent data, 80% of all patents receive at least one non-final rejection, and it's common to receive 3 or more. That makes SMBs use less of their time to actually profiting off of their innovation, but having to fight them in court. And moreover, with every non-final rejection and every time you have to amend your patent, that is more money taken away from SMBs because they have to fix this. Our plan is going to help this because the education aspect of our plan specifically works with SMBs to help them with non-final rejection rates. The specific things that they are violating in their patents is just clarity and vagueness. vagueness, which is just how they file their patent. It has no issues with what they're inventing, but how they file them, which shows that there's a lack of education. Our plan specifically works with educating SMBs on how to file patents that don't violate these areas, which is U.S. Code 102 and 103 in the America Invest Act, to be specific. Our plan is different than what the negative has already stated because we focus on SMBs in particular, who are the backbone of innovation, and we are helping them specifically with non-final rejection, which shows a major difference in our plan. The negative has also poked holes in our budget. They said that each year the USPTO is going over budget. That is true. The USPTO has been going over budget, but that is not the same as using their entirety of their surplus. I have right here the stats for the USPTO's operating levels for their fiscal year 2025. They project that they're going to have an operating reserve, aka a surplus, of $925 million. That is a huge number, and there's no way they can even go overboard on that. The whole point of the surplus is to be used in times of need, and our plan is taking these existing fundings and using them. We're only pulling about $200 million from the surplus each year, and the USPTO tends to put about 30 to 40 million back into that surplus each year just to maintain it when they need it. That shows that our plan isn't taking a huge deficit from it, but we're only utilizing existing resources. They have also brought up the fact that apparently the USPTO cannot claim any discretionary fundings. That is completely untrue. Yes, it is true that the USPTO is a fully fee-funded agency, and that's their main source of funding. But it's true that any U.S. organization or office can use discretionary fundings. That is what they're there for. Congress has to spend a specific amount of discretionary fundings on their offices each year because they need it. And the USPTO has, in the past, used this discretionary funding. In recent decades, they've pulled about 30 to 40 million from the U.S.'s discretionary funding when they've really needed it, when they've gone over budget. This shows that it is not illegal for the USPTO to use any discretionary funds, because that is the whole point of discretionary funds, to be used to help the public. Moreover, our program is building on existing infrastructure within the USPTO, and we're collaborating with local partners and businesses, which is going to make implementation more manageable than it may appear. The USPTO already has established an online filing system and support mechanisms, and our plan is going to extend their expertise to support more SMBs, which are the backbone of our innovation and our economy, especially in this trade war with China. We are not reinventing the wheel. We're simply expanding it to fit modern needs. The beauty of our plan is in the fact that it is significant in what it does and its results, while not being complicated or costly. Furthermore, our workshops, our online resources, and patent education centers are specifically designed to address the needs of the IP climate. We're specifically helping these SMBs, which is in turn allowing them to file better patents. The patents that these SMBs are hoping to be filed aren't going to be worse. In fact, the whole point of our education is going to be making them better. The education is going to help them file better patents that don't get these non-final rejections, in turn being able to profit off of their patents better and push more products, which is going to encourage innovation and stimulate economic activity. By making patent education accessible, we empower SMEs to navigate IP law effectively while protecting them from the costly and time-consuming pitfall of the patent process. I would like to clarify how we're going to be implementing this. As we stated before, we're going to be hiring about 100 to 150 new employees. They're going to receive a budget of about $100,000 each year. The total amount for hiring new employees, advertising, maintaining things, and just going over these costs are going to be about $25 million. That's the total part for that plan. And we're using that budget to do advertising for our program to make sure that every SMB knows that they can use that. It's there to help them. We're using them to pay our staff, which are obviously critical in implementing any plan. And we're using them to update existing infrastructure at the USPTO by obviously putting in these new resources, this education, and implementing our program. The legal fund of our plan, moving to that, each SMB will receive this if they go to court with these registered patent trolls that are registered in the FTC's database. They're going to define what a patent troll is based on what patents they hold, who they're attacking, how many times they're going to court over patent trolls. We do not have specific numbers and the specific qualifications for what a patent troll is in this database, but the FTC has already created this. It's an already existing thing. And each SMB, if they go to court, can receive up to $150,000 in patent to help them with their patent litigation. Thank you for your time, and please side with the affirmative.
Can you elaborate on the seminar aspect of your plan? Is that going to be online or in person?
Both online and in person. We're going to be creating online seminars and online webinars with.
Can you specifically touch on the in-person part?
Yes. So we're going to be hiring temporary employees with this $25 million part of our plan, and
Across all 50 states?
Yes.
How many employees?
We don't know. We don't know yet. We're going to look at historical trends and data once that plan is actually implemented.
Thank you. So you also stated how your plan is going to be different than the plans we've already stated because it addresses small and medium businesses, correct?
Yes.
Are you aware that the plans that we've already stated do address small businesses?
Yes. While they may apply to SMBs, we're specifically addressing the needs of SMBs who are critical to innovation and the economy.
Can you elaborate on how there can possibly be a surplus in the USPTO if there's, as you acknowledge, there's always a deficit?
No, I did not say there was always a deficit, but I was saying that, yes, it is true the USPTO can go over its set budget, but there is still going to be a surplus.
How is that possible?
The USPTO always keeps its surplus in cases of emergency, and each year for the past decade,
So in
it's
case
been
of
about...
emergency, correct?
Yes.
Is this classified as an emergency?
Well, I wouldn't say just an emergency.
So then how can you justify
It's not
taking
a-
money from this fund?
It's not always used in like just emergency, but whenever they need to dip in their funding, whenever they go overboard in what they
They've been in
projected.
deficit the last 3 years.
Yes,
Where they've had
and
to
they've
use
been-
this money, correct?
Yes.
So how is taking an emergency fund reliable and or good for the organization?
Well, because we're only using $200 million out of their about $1 billion deficit, and we're not taking much from it. It's being replenished almost each year.
Okay. So are you aware of how new the plans you suggested are specifically?
I do not know their specific dates because you did not state them.
Okay. So how is the advertisements going to work? You stated advertisements, correct?
Yes. The $25 million is going to be, some of it is going to be used towards online and like in-person advertising, saying, hey, this plan exists.
Through what channels is advertising to be done? Is it going to be done through like TV, certain news articles? What
Yes.
kind of advertising?
Pushing out news articles, TV advertisements, online advertisements, like just advertising that this program exists and it is being able to be used by SMBs.
Okay, thank you. Okay, that's it. Thank you.
Thank you.
Good afternoon, Honorable Judge, worthy opponents, and fellow teammates. My name is Sunday Amithikaran, and I'm N2 from the Robbinsville Debate Team. I would like to begin by addressing the USPTO Patent Pro Bono Program as referenced by our team and rebutted by the affirmative team. The affirmative team has argued that the USPTO Patent Pro Bono Program is currently not achieving what it was intended for or may have insufficiencies and therefore their plan is qualified as necessary. However, we're not saying that the USPTO Patent Pro Bono Program is perfect, we're just saying that such a framework already exists. The implementation is the issue there and therefore its efficiency can be increased. The creation, the idea of an actual program to provide legal fee aid and comprehensive education isn't something that is new. The idea has already been created, and the implementation can therefore be made better. However, it does not require a very similar exact plan to be recreated again. The program already exists. Therefore, it should just be made more efficient. It doesn't need to be recreated or reinventing the wheel, as the affirmative stated. They also went on to say that the reason their plan is required is because there's a disparity of SMP filing, since there are 99.9% of businesses in the United States are SMPs and only about 45% who file patents. But the statistic is ineligible to the argument because not every small business pursues a patent, because not every small business is based on innovation or the creation of original ideas. Therefore, this problem isn't exactly relevant to our debate today. Additionally, I would like to address topicality very quickly. Their plan overall touches on increasing accessibility. However, I fail to see how this exactly touches on patent protection itself. If you increase the accessibility of SMPs to file the patent, that doesn't necessarily mean that they are more likely to receive an acceptance of their patent in a legal framework. If they're trying to address the fact that most SMPs, when they file patents, receive non-final rejections, as they said, the outcome of litigation is independent of accessibility. Increasing accessibility of SMPs to file the patent itself does not guarantee them the outcome of getting that patent. Therefore, if they wanted to increase the accessibility of SMPs to receive a patent, that's impossible because it is up to the litigation to decide that, and increasing their ability to file that in the first place doesn't change this. I would also like to state that overall, supporting SMBs, which I would like to say are 99.9% of businesses in the United States, and when asked to the affirmative team how they're going to qualify these SMPs, they said the FTC has certain requirements. However, beyond this, they did not qualify what specific metrics they're going to be using to decide which of these 99.9% small businesses qualify for their legal aid. Is there a certain annual income requirement? Is there a percentage? Is there a time period that a patent has been unfiled? These sort of metrics haven't been discussed by the affirmative team. Rather, they've been thrown off to the FTC and said that they have requirements. What these requirements are, I do not know because they have not stated in either of their constructives at all. I would also like to say that any and all businesses is what they stated in the first affirmative when they said how they're going to qualify which SMPs are going to receive their aid. If we decide to consider any and all businesses, then this is infrastructurally impossible because providing legal aid to any and all businesses is monetarily impossible. Touching on funding, the affirmative A2 conceded that the USPTO for the past several years has been consistently overspending or have been in a deficit. They said that their definition of surplus is the fact that a discretionary fund exists. However, as my partner stated, this discretionary fund exists for emergent purposes or purposes that the USPTO already currently is taking care of that have been inadequately performed. It does not cover new initiatives taken by the USPTO. That is what a discretionary fund is. It is money available to use if the initiatives taken by the USPTO, if they run out of funding, basically. However, using this discretionary funding to allocate towards an entirely new purpose isn't possible. And in reference to the appropriation clause that my partner stated, the affirmative team has misunderstood the appropriations clause. The appropriations clause doesn't say that the USPTO cannot use its discretionary funding. It absolutely can. The appropriations clause just says that the USPTO cannot use that discretionary funding for a purpose that hasn't already been defined in the inherent creation of the USPTO, namely such as a new program or a new initiative taken by the affirmative. This discretionary fund can only be used for existing initiatives that aren't being adequately performed or emergency needs, and this program isn't an emergent need whatsoever. Additionally, I would like to state that the affirmative said that SMPs, when they file a patent, the reason that they need aid is because they often have non-final rejections, or perhaps their patent might be rejected, or there may be an inherent disparity between large organizations and small organizations. However, they haven't considered that because 99.9% of businesses in the United States are SMPs, a majority of the scenario, an SMP is filing a patent, or if it's questioned, it's in a litigation battle with another SMP. It's a rare instant that this SMP is against a large organization or patent trolls, as the affirmative stated, but because 99.9% qualify as a small business, then these small businesses are going against other small businesses in their litigation processes, and it's not necessarily that these large organizations are taking advantage of these small businesses. I would also like to state that when we're on this topic, the affirmative has failed to consider that these large organizations can use shell companies or go through a small business in order to gain that patent in the first place. And in fact, this is why so many patent trolls are successful, because they use a shell small business to acquire that for the overall conglomerate of the large organization. Therefore, it is difficult in an actual litigation when a patent is filed to determine if it's a shell company. That is the USPTO's biggest problem when it comes to identifying patent trolls. Is it a large organization, or is it a small organization posing as a small organization that is truly backed by a large organization, or is it actually a small business? And this hasn't been identified by the affirmative team at all. I would also like to say that in terms of the educational aspect of the SMP, while it is morally applaudable, it is not the problem when it comes to litigation that they are trying to achieve. Education is not the issue here. If an SMP knows how to file a patent and files it successfully, that's great, but the issue of fighting the amount of funding it requires for that SMP to uphold the patent comes from the fact that litigation is so expensive and the length of that duration. It isn't from a lack of organization or not correctly filing the patent itself, but because that patent is trapped up in patent thickets within the court that the filing takes so long and the SMP is unable to support itself. Therefore, I would like you to consider the lack of funding, the lack of addressing the exact issues they're trying to address. Thank you, and please side with the negative. Good afternoon.
So, can you give me the definition of a discretionary fund?
A discretionary fund is used when a funding that is allocated to an organization ends up falling short, so that discretionary fund can be used for the same purpose for which its funding has fallen short.
So where does that discretionary fund come from?
In this regard, it would be the USPTO.
Are you aware that discretionary fundings come from Congress?
Yes, that is how it's given to the USPTO.
Can you define an operating reserve?
An operating reserve is similar to a discretionary fund in the fact that it is reserved in case operations led by the USPTO end up not having enough funding, so that operation reserve can be used. However, in the past few fiscal years, this operating reserve has been used entirely by the USPTO.
Thank you. Are you aware that in the fiscal year 2025, the USPTO is going to have an operating reserve of $925 million?
Yes, but I also know that the
Thank you.
USPTO has
Thank
projected
you.
that this operation reserve will be enough.
So you claim that the USPTO is using almost $1 billion from their operating reserve, yet,
I didn't claim this.
but you keep claiming that they're using their entirety of the operating.
Yes.
Then how did if the USPTO used the entirety of their operating reserves in the last few years, then in this fiscal year,
Is there a question?
Yes, in this fiscal year, how do we end up with an operating reserve of $925 million?
I failed to understand the question.
You stated that the USPTO has used up its operating reserves in
Yes.
past years,
Yes.
correct? So then how in this year, this fiscal year, is the USPTO having an operating reserve of $925 million?
Because the USPTO regarded it necessary to be allocated that money. However, I failed to see the connection between money allocated
Thank you.
and money used.
So you stated that we haven't stated how patent trolls are going to be defined. Are you aware that in both of our constructives we stated that the FTC is maintaining a database?
I conceded that you told me who has these requirements. I said that you didn't define what these requirements are.
Okay, thank you. Are you aware that according to the U.S. Small Business Advocacy Office, 64% of all patent litigation cases were filed by patent trolls?
Sure.
Do you know how many patents in recent years were rejected for missing information?
No.
Are you aware that there is an issue with how patents are being filed in this country?
Sure.
Would you agree that better education would lead to better patents being filed?
I agree that better education would lead to better patents being filed, but better education does not guarantee that that patent comes back and is accepted.
Okay, thank you for your time.
Thank you.
Good. All good?
Good afternoon, Honorable Judge, worthy opponents, fellow teammates. I will now present my rebuttal for the negative team from Robbinsville. First, I would like to summarize the arguments that have been made in this debate throughout, and I would like to start with the inherency aspect of this argument. The pro bono patent program underneath the USPTO already exists for the provision of free legal aid and educational services, and because this idea already exists, there's no need to create a similar initiative. Even if the initiative is currently insufficient, it is because of the lack of funding that the USPTO currently has to begin with. Therefore, even if this problem existed, it's not being addressed by the affirmative by taking more money from a place where it isn't existent. I would like to move on to state that, as my partner stated, the driving U.S. innovation is a very important aspect of this nation right now, especially considerate to AI, as my partner mentioned. Innovation is a key need in our country. Therefore, by increasing patent accessibility in terms of strengthening patent protection, we are just going to be increasing the patent thickets that are already existing in legal frameworks, or I'm referencing the amount of patents that a court has to get through, and therefore the time work that this litigation needs. I would also like to state that the affirmative stated that part of a problem that they're trying to address is the fact that there are non-filing rejections or non-final, or basically outcomes that are not favorable to the business filing the patent. However, I would like to state that educating them more on how to implement this patent doesn't guarantee that that patent will come back accepted by the court, as it is individually determined by these independent courts, and providing them with legal fees or education doesn't guarantee them an outcome at all. I would also like to state that in terms of topicality, their plan does touch on increasing accessibility. However, as I stated before, I fail to see how this will increase actual patent protections for the SMBs, as there is no support in terms of protecting that idea or enforcing that law, but rather just the fact that these companies can file patents easier. Another important aspect of this entire debate is an utter lack of qualification. The affirmative team did state that they're going to leave it up to the FTC to determine and use their existing requirements. However, what these requirements are, they never stated. Therefore, I cannot qualify if these 99.9 businesses that they said they're addressing can be compromised in a way that is logically or logistically, infrastructurally possible to address, because I don't know what these requirements are. Therefore, if 99.9% of businesses are being addressed, this is financially impossible. I would also like to state that in terms of their funding, they have divisions of $625 million to education. However, their funding framework, the entire purpose of it being derived from some USPTO surplus does not exist, because the USPTO has been in deficit the last couple of years, which A2 even conceded. However, this discretionary fund was created for the purpose of being applicable to initiatives currently undertaken by the USPTO if there is a legal shortage or funding shortage, sorry. However, it does not at all can be applied towards new initiatives or plans. And in terms of an operating reserve, again, operating for current initiatives or current implementations that are financially not being satisfied, that is what the discretionary fund or operating reserve can be used for, not for entirely new purposes. Thank you, and please side with the negative.
Once again, good afternoon, Honorable Judge, worthy opponents, and esteemed colleagues. Today, I stand strong in our affirmation of our plan. The negative has brought up very good points, but they lack in being substantial. The negative has stated that the pro bono plan is already in place, but we have consistently proved in our harms that this plan is not working. We've stated that 80% of all patents filed receive a non-final rejection, and it's common to have 3 or more. This is a harm for our plan. Our plan is half of our plan. The education aspect of our plan is protecting SMBs from this non-final rejection. The negative has stated that this is topical, is inherent, that this is our inherency because we're not protecting them from that. As we stated before, our plan is protecting SMBs from the high non-final rejection rate and from patent trolls. That is who we are directly protecting SMBs from, which connects directly to the result. They have also stated that our plan is increasing accessibility, not protecting. Our plan is not increasing accessibility. We are better educating SMBs to help them file better patents. We're not helping them access patents better, but helping them file patents better. That is a difference. They have also stated that the pro bono plan is already in place, so why use our plan? Well, the pro bono plan has not been working well, and moreover, that is an old plan, and they haven't even stated the years of when it's been in place. The USPTO makes goals each year, and some of their goals have been promoting the efficient delivery of intellectual property and promoting their protection. They do not have any plans in place for this, and our plan is responding to that. The fact that they bring up other plans, such as the pro bono plan and their other legal plans, is actually fiat because they're trying to bring another plan in access to resolve instead of our plan. Moreover, the negative has been unable to correctly say what a deficit is versus what an operating reserve is. They have stated that the USPTO has been going into deficit. That is true. That is because the USPTO every year projects how much money is going to be used that year. And if they go over budget, that would be going into deficit. That wouldn't mean that they're going over the amount of money they have. That's just the amount of money they wanted to spend. The surplus, on the other hand, is their pocket change in case they go over that budget. Each year, it's been about $1 billion. In fiscal year 2025, the operating reserve, the surplus, that's what it is going to be $925 billion. Even if the USPTO goes way over their budget and goes into a deficit, there is no possible way they could use that almost $1 billion surplus. And our plan is only going to be pulling $200 million from that. So there really is no funding shortage from the operating reserve, aka the surplus. They have also stated we only have that one form of funding. That is simply not true. We have our use from the surplus, and we have our use of discretionary funding. And moreover, Congress gives the USPTO and other agencies this discretionary funding to be used when they need it. And this is an instance of needing it. We have outlined the many harms, including how 64% of all patent cases are filed by trolls, patent trolls. Thank you for your time, and please vote in the affirmative.
All right, thank you everyone. So we thought we would share some of our observations and commendations for both teams, and then we will let you know who ultimately won the matchup tonight. So I'll begin. Affirmative team, Notre Dame, Patrick and Ash. Hello. Very good to see you in the final round. So some strengths that we noted in your performance today. We were all familiar with the plan, from the early weeks of the season. We thought it was really tightened up. The solvency was quite strong with very well thought out planks, very well articulated in both constructives. Both of you improved your delivery over the year, so continued good poise. Ash, especially, very good clash in your constructive. Also, in your A2 constructive, good turns. using the negative talking point about China to your advantage and saying that they have acknowledged this trade war that you then rolled into potential harms. And also taking the dissad about stifling innovation and saying, well, the SMBs are the backbone of innovation. So good job pouncing on those available talking points. So well done to both of you.
A round of applause. All right, so I'm going to comment a few things that we had saw regarding the negative team. Robbinsville, excellent job. Sonia and Raymond. So first start off the unbelievable matter-of-fact approach to recognizing the gaps within their plan as juxtaposed to the status quo and the arms within the resolve. Really well done, both Ray and Sonia, for that. The preparation with the counter-arguments really demonstrated your ability to research and to collect evidence, the appropriate evidence, not just ambiguous evidence. And also identifying the framework, the disadvantages of the framework within the plan. You were very particular and you took your time in kind of dismantling it a bit, and that served you well, specifically with trolls and the metrics. All right, so very well done.
So there has to be a winner, and so we felt like there was one side that did a really good job kind of going through as far as inherency, topicality, harms, did a really good job kind of pointing out the flaws and holes, and we felt negative did a good enough job to cast it down, so negative, you guys.